5 seconds. Start. This special leave petition has been filed against the judgment and order passed in Writ Petition number 10 of 2008 by the High Court of Andhra Pradesh, by which the writ petition against the order of dismissal of the petitioner's application and successive appeals under the Right to Information Act 2005, hereinafter called the RTI Act, has been dismissed. In the said petition, the direction was sought by the petitioner to the respondent number 1 to provide information as asked by him wide his application from the respondent number 4, a judicial officer, as for what reasons the respondent number 4 had decided the miscellaneous appeal dishonestly. The facts and the circumstances giving rise to this case are that the petitioner claimed to be in exclusive possession of the land in respect of which civil suit was filed before Additional Civil Judge Rangareddy District, praying for perpetual injunction by Dr. M. Rao against the petitioner, and another from entering into the suit land. Application filed for interim relief in the said suit stood dismissed. Being aggrieved, the plaintiff therein preferred CMA number 185 of 2002, and the same was also dismissed. Two other suits were filed in respect of the same property, impleading the petitioner also as the defendant. In one of the suits, the trial court granted temporary junction against the petitioner. Being aggrieved, petitioner preferred the CMA number 67 of 2005, which was dismissed by the appellate court. Respondent number 4, White order dated 10/8/2006. Petitioner filed an application dated 15/11/2006 under Section 6 of the RTI Act before the Administrative Officer cum Assistant State Public Information Officer, seeking information to the queries mentioned therein. The said application was rejected. Wide order dated 23/11/2006, and an appeal against the said order was also dismissed. Wide order dated 21/2007. Second appeal against the said order was also dismissed by the Andhra Pradesh State Information Commission. Wide order dated 20/11/2007. The petitioner challenged the said order before the High Court, seeking a direction to the respondent number 1 to furnish the information as under what circumstances the respondent number 4 had passed the judicial order dismissing the appeal against the interim relief. Mr. V. Rao, Learned Senior Counsel, appearing for the petitioner, has submitted that right of information is a fundamental right of every citizen. The RTI Act does not provide for any special protection to the judges. Thus, petitioner has a right to know the reasons as to how the respondent number 4 has decided his appeal in a particular manner. Therefore, the application filed by the petitioner was maintainable. rejection of the application by the respondent number 1 and appellate authorities rendered the petitioner remediless. Petitioner White application dated 15/11/2006 had asked as under arguments and additional written arguments as the ignorance of the same tantamount to judicial dishonesty. The respondent number 4 omitted to examine the fabricated documents filed by the plaintiff, and for what reason the respondent number 4 omitted to examine the document filed by the petitioner. Similar information had been sought on their points. At the outset, it must be noted that the petitioner has not challenged the order passed by the respondent number 4. Instead, he had filed the application under Section 6 of the RTI Act to know why and for what reasons respondent number 4 had come to a particular conclusion which was against the petitioner. The nature of the question posed in the application was to the effect why and for what reason respondent number 4 omitted to examine certain documents and why he came to such a conclusion. Altogether, the petitioner had sought answers for about 10 questions raised in his application, and most of the questions were to the effect as to why respondent number 4 had ignored certain documents and why he had not taken note of certain arguments advanced by the petitioner counsel. Under the RTI Act, information is defined under Section 2F, which provides information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material held in any electric form, and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. The definition shows that an application under Section 6 of the RTI Act can get any information which is already in existence and accessible to the public authority under law. Of course, under the RTI Act, an applicant is entitled to get a copy of the opinions, advices, circulars, orders, etc., but he cannot ask for any information regarding their passing.